Yeah, we don't have any record of why. He must be undocumented. Then, at that point, the county attorney is to bring a enforcement action in the county commission, have a contested case proceeding before the county commission, and then an appeal is a hearing de novo in the justice court. That's the enforcement mechanism. If the court's satisfied on that point, I would move on to some of the constitutional issues.
And I was just giving a little thought to that process, and as was identified earlier, what do we do in those areas that do not have a justice court? I believe in Columbia County we have 2 justice court areas, and there's a significant portion of the county where there is no justice court, and I guess that's just one of the unexplained concerns that you.
We don't have county attorneys either, so
right.
That's the nature of the problem.
So I believe that the Clasconi area, the Vernonia area has a justice of the peace, but I don't believe there is any similar justice court in St. Helens or Scappoose area, and so I guess that's just a concern. I guess well, let's go ahead and move on.
Okay. With respect to the constitutional issues, I want to start out by saying that the issue that you first inquired about is not properly before you at this point, and that is the question of the interaction between federal immigration law and this ordinance or motivation. Neither is the question, by the way, of procedural due process. The reason I say it isn't before you is no one moved for summary judgment on these issues. That issue is presented in the county's case, and we've raised that argument. We did not move for summary judgment, and the reason we did not is because one of the questions you have to raise in a due process claim is what process is due. And part of the question is what process is available here in the county, and that's set out in writing, but there's also the question of what, if any, process might exist with respect to the federal government, and that would involve some development of evidence, and given the time frames that would involve, we didn't feel it was right for summary judgment. Because there is a profound interrelationship between the federal procedural due process claim and the federal preemption claim. And the reason for that is this. You either have a state hearing or you don't. If you have a state hearing, then state officials have to be able to make a determination about whether Joe the plumber employing Juan Garcia, whether Juan Garcia is or is not documented. If you're going to have due process as a practical matter, and that due process comes in the justice court or the county commission, then those officials have to be able to decide that question, or the process you have is meaningless. If those people are deciding those questions, that raises profound interests, profound questions about federal preemption. So because those two are interrelated, and we need some more development of fact on the due process claim, that we did not move, and there's a footnote, I think, in
So are you saying that, let's say the complaint is made, it's investigated, county attorney says, I don't think this person is documented, and so now we go to the county commissioners, and you're saying it's really up to the federal government to decide whether or not this individual is lawful in the country or not?
Well, that's what the ordinance seems to say. Where's your process? to contest that? Is there a federal process to contest that? We don't believe there is, but we don't think that evidence is before the court. Or is your process to contest that is to say to the county commission, look, I mean, I know Juan, he's married to my sister, and I was there when he was sworn in. I don't know what basis you'd be making that, but it seems to me procedurally, Joe the plumber has to have some place to go where a competent authority can hear his appeal about that, and we don't know where that would be. But as I'm saying, I think that's not before the court at this point because nobody's moved for summary judgment on that ground. There are constitutional issues that are before the court. And the first one is the question of taking of property. If you basically, whether you're talking about the 5th, 14th Amendment to the U.S. Constitution or Article 1, Section 18, whichever way you go with that, essentially the test is roughly the same, and that is that if in essence you deprive someone of meaningful use of their property, that's taking that has to be compensated, or it's unconstitutional to take. Also, you have to. The regulation has to substantially advance a legitimate state interest, and we argue that this doesn't really advance a legitimate state interest. And whether there would be interference with investment-backed expectations by virtue of the taking. And if you have someone who's invested in a condo project that is expected to go forward, and all of a sudden, they can't use that land at all because they can't get a building permit, and this law, in some circumstances, bars people in perpetuity.
So even though the landowner in good faith went out and hired a contractor he felt was living up to all necessary laws, including this local ordinance, and it's found out that he has hired illegal immigrants, when that building permit is revoked, if at all, it's the landowner that is not able to use that land arguably forever because they can't get a building permit.
Well, the landowner may be able to get a different building permit with a different contract. So that wouldn't quite apply. But the landowner may be the contractor.
But also, is the building permit, isn't it issued to the landowner and not to the builder? I mean, the builder may go in and do what's necessary to acquire it, but the contractor isn't the owner of the building.
Well, this is another problem with the statute. Before I leave that constitutional question, that issue is probably not as explicitly pled in our complaint as we would want it to be. We've drafted an amended complaint to reflect that. We've amended once to make some corrections and so forth, so we would need leave the court to do that. We have a drafted amended complaint, but as counsel mentioned,
there's opposition to it.
Well, there's opposition, and we haven't really had the opportunity to confer in good faith about it. So there isn't a motion before you at this point, but there will be one forthcoming to amend on that issue. There's no undue surprise because we briefed it thoroughly in our motion for summary judgment. The next issue has to do with